Right, thanks all for joining. So today we're going to be talking about outsourcing and third-party contracts. I'm going to be talking for around about sort of 35 to 40 minutes today, going through the slide content. At the end of the session, there will be some time for general discussion, questions, answers, that type of thing. So please hold off any sort of queries until the end or put them in the chat, as Pete mentioned. The session today should be eligible to be counted as structured CPD, should you consider it as relevant to your learning needs. Learning objectives are up on screen. The slides themselves will be available on Buddy later on today. In terms of what we're going to cover, we're going to talk about what the key regulatory requirements are for firms in respect of outsourcing and engaging in third-party contracts. We're also going to talk about what the difference is between outsourcing and a third-party contract for services. And we're going to talk about some of the key considerations that the FCA expects firms to have when they look at outsourcing activities, services or functions, and likewise what the key expectations are in respect of contracts with third parties. We'll then also have a chat around what some of the key requirements are under Movo's policy related to outsourcing and third-party contracts. I would just start off by flagging that today we have published on the extranet 2 new policies related to outsourcing and third-party contracts. Today we're going to be summarising quite a lot of the content of those policies, but you can find those policies if they're relevant or you need to look at them on the extranet, well on Buddy, by going to the compliance folders and then looking for outsourcing. The relevance of this topic to insurance intermediaries is that the most likely use of this sort of stuff, I would suggest, is probably in the event that you would actually sort of look at bringing in external resource to support your outsourcing activities to an agency or a company to actually help you and provide additional human resource effectively. So that's probably the key application of this stuff for most of the firms that are on the call today. And that's probably where I'm going to sort of focus the conversation, the direction of it effectively. So, and Movo's interest in all of that obviously is, as we're firm principal, we're answerable to the FCA. So in terms of any arrangements that you have with third parties which could impact on your operations or your clients, Movo's firm principal again has an obligation there to make sure that we've got policies in place that cover that, guidance to support you, and that we've got appropriate supervision in place where you're putting these sort of things into place. We're far more interested in where you actually outsource, which I'll define for you in a few moments, than where you have third-party contracts for general services, and I'll explain why in a few moments. So, as with all of these things, probably the starting point is to define the key terms. So the key term in this region is outsourcing. So the FCA defines an outsourcing as any form of arrangement between a firm and a service provider, by which the service provider will perform a process, service or activity which would otherwise be undertaken by the firm itself. There's a key part to that phrase, which would otherwise be undertaken by the firm itself. And the reason I'm flagging that is that if you are reliant on a third party to do things for you, but it's things that you wouldn't normally do yourself, so it's not sort of linked to insurance distribution directly, then in that instance, it's not actually outsourcing. It's a contract for third-party services. So I'll give you a list of some examples of that in a few moments, but it's that key point to keep in mind that if it's not something that you would normally be able to do yourself, and it's not going to be outsourcing, and much of this stuff has a lower level of application. The FCA also has a term which is material outsourcing. Now, the importance and the relevance of that term is that if you have what's called a material outsourcing arrangement, the FCA has much firmer rules and expectations about what's required from you and would be required from us. In the event of a material outsourcing, there is a requirement to let the FCA know about the outsourcing well in advance of it actually being put into place. And a lot of the bits and pieces that the FCA has published, which would otherwise be guidance, become hard and fast rules. So whether or not something's material from an FCA point of view is it's a fairly critical decision to make. By and large, within Movo, we wouldn't expect that any of our ARs would have what we'd consider to be a material outsourcing arrangement, because material outsourcing arrangement will normally be a large-scale outsourcing arrangement or putting a large degree of reliance on an external third party for your business functions. The FCA definition is it's an outsourcing arrangement that is of such importance that any weaknesses or failures of the services would cast serious doubt on the firm's satisfaction of the threshold conditions or compliance with the principles. So effectively, what that means is that if you had a outsourcing that would lead to the firm being shut by the FCA if it went wrong, that would be material in effect. As I mentioned earlier, we wouldn't really expect that any sort of outsourcing arrangements that would be looked at by our ARs is ever going to fall into that category. So we've talked about in brief about what a outsourcing arrangement is and what the definitions for that are. There's going to be many instances where a regulated firm is going to be sort of procuring services from external firms and getting services outside of their own business. The rule of thumb is if those are services that the firm itself cannot carry out, then that won't be outsourcing, it's a contract for service. The FCA is still interested in how firms manage contracts for services that they have. So they're still expected to sort of have care about who you engage, on what basis, monitoring performance, and all of that sort of stuff. But the rules are a lot less prescriptive. So from our point of view as firm principal, supervisor, again, our policy requirements are a bit less prescriptive in terms of sort of contract for services, in that we don't particularly need to be notified of any of these. We don't need to be particularly involved. We've just sort of outlined some of the guidance, some of the things that you need to think about generally in terms of sort of managing your contracts externally. But in terms of what the FCA defines on this, so we've got some examples on the screen of things that they say would not constitute outsourcing for a regulated firm. These would be contracts for services, and the reason being, simply put, that these are things that you wouldn't expect your typical regulated firm to actually do themselves in-house. So, for example, purchasing hardware, furniture, you're not manufacturers of furniture. You're going to expect that you're going to actually have to go out and buy that either directly or through somebody that actually takes care of those contracts for you. Likewise, cleaning, doing audits, again, statutory audit, if you're subject to that. Again, I wouldn't expect many of our firms would be, because that's actually got quite high thresholds for that. But again, wouldn't expect you to have those sort of in-house necessarily. Legal representation. So again, most firms wouldn't actually be expected to have their own legal team in-house. So again, going and get external legal support, that isn't actually outsourcing, it's contract for services. And so subject to a lower degree of FCA rules in essence. In terms of other things, so for example, using banking systems, banking infrastructure, all of that sort of stuff, again, it's not classed as outsourcing because it's not something you're able to do. And then buying of standard off-the-shelf software. Again, that one I thought was quite sort of pertinent because we all use software. By and large, if you're using external software, that is going to be contract for services as opposed to being an outsourcing. Even if you have some say on the software, so for example, if you've got something that's white labeled like Actress, where you can get your name on there, your brands, and you can get sort of bespoke wording into some of the letters and stuff like that, even in that kind of scenario, that isn't going to be outsourcing, it's contract for services. They've sort of got the intellectual property, they have the ownership, you're literally paying a fee that sort of gives you access to actually make use of it effectively. So that kind of scenario, all of those sort of scenarios, contracts for services, not outsourcing. So there is still an expectation that you'll have some degree of awareness of those and taking care to manage them to make sure that there's no adverse impacts on your firm, no adverse impacts on your customers. But by and large, the actual application of the rules is a lot more woolly, I'd probably say. The only thing I would say is that obviously if you have a contract for services that goes badly wrong, that interacts or causes problems for your continuity of services and leads to client detriment, then in that instance, though that we say that the rules are less prescriptive and less applicable for contracts of services, they're a bit woollier, you'd still be at the point there where the FCA would be quite happy to sort of point the finger and say, well, you're not managing things properly. So whilst the rules are a little bit more lenient in many ways, where it's contract for services composed to outsourcing, the point is that it's still general guidance, good business practice. So pretty much the case is there's not going to be a great deal of difference in terms of how you should approach it, generally speaking. So in this area, the main concerns for the FCA in respect of outsourcing and managing third-party contracts for services is operational resilience, as in continuity of services. So all of the fines that we've seen from the FCA historically in this space have all been around where firms have actually used a third party, the third party's let them down in one way, shape or form, and it's then led to bad outcomes for customers. They're not greatly interested in what it means for you commercially. They're really focused on sort of, does it sort of impact on your continuity of services, and could it lead to actually harm to your customers effectively? There's quite a lot that the FCA's had to say about this sort of stuff. So there's various publications, which I'm going to talk about in a moment, but the point was to principle for business number 3, saying that firms must take reasonable care to organise and control its affairs responsibly and effectively with adequate risk management systems. External contracts need to be sort of part of that adequate risk management. And then principle for 11, a firm must deal with regulators in an open cooperative way and must disclose to the FCA appropriately anything relating to the firm of which the regulator would reasonably expect notice. So that principle for business 11 has several applications. So if you were ever going to enter into a material outsourcing arrangement, you'd be expected to send a principle 11 notification into the FCA to let them know that you're going to be entering into a material outsourcing arrangement. That would need to be done with sufficient time for the FCA to actually look at what you're proposing and challenge back if they had any concerns, because they may want to interfere. Wouldn't expect, as I say, that we would have any material outsourcings within our network as such, but it's worth just being aware of. There is also a secondary application of principle for business 11 in that if you are using a third party, you've outsourced something, if something goes badly wrong and there's client detriment, then at a certain threshold of client detriment by volume, so number of clients affected, or by severity of impact on individuals, i.e. financial detriment and such like, there does come a point where we and you would be expected to let the FCA know if that actually occurred. And again, that's an application of the principle for business number 11. Again, it's not something we'd expect to see much of, but we have seen instances where people have used sort of third parties like virtual assistants, and it's actually led to complaints because the service from the virtual assistant has been quite poor. We've not yet reached the threshold, I think, on any of those recently where we've actually said there's a need to go to the FCA, because it's all been sort of fairly low level stuff. But it isn't inconceivable it could actually happen. So it's worth just being aware of. In terms of FCA publications, so there's a raft of stuff out from the FCA in this area. Most of this, if I'm honest, I would say is aimed at your large institutions like banks, because they've got much more ability to actually make one mistake that actually has a huge impact on the UK economy than we do as individual insurance brokers. But at the same time, there isn't much of a carve out from the regulations for us. So the FCA basically takes the view that there's rules there that they apply to most types of firms, and if they don't apply directly and if they relate to materiality, then even if they don't apply on the nose, then you still have to consider them as guidance and actually apply them in a proportional and sensible manner. So it still actually has teeth, so to speak, in this area. So some of the key resources are, they've got a web page on this. They've got a Systems Controls Handbook 8.1, which talks about general outsourcing requirements. So that's kind of the Bible on this effectively. You've then got a chapter on in SISC 13.9 on outsourcing, which applies to insurers. So insurers need to sort of be aware of that. And again, some of the points there overlap greatly with SISC 8.1. And then you've got general expectations for firms to have systems and controls in SISC 3.1 and general organisational systems in SISC 4.1. And all of those point to the need to sort of make sure that when you are sort of outsourcing or engaging a third party, you're taking some degree of care about how you pass tasks over to them, what your contractual terms are, and actually sort of, approaching things in a fairly professional, business-like manner, as opposed to, being negligent, haphazard, and hoping it all works out okay. And we'll talk about a bit later on in a bit more detail about what the expectations are for due diligence and such like. In terms of FCA publications, there's been quite a slew of those over the years. Some of those have been focused on the insurance industry rather than banking. So, for example, you've got Thematic Review 15.7, which is delegated authority, outsourcing in the general insurance market. The main finding of that one was basically that insurers were sort of putting in place arrangements for delegated authority, but weren't actually recognising that that's a form of outsourcing and weren't actually applying the FCA's requirements to it. So they're actually pretty unhappy with that. They also did a review on how insurers were outsourcing claim activities and claim investigations to private investigators back in 2016. There was a finalised guidance document in 2016 about outsourcing to the cloud, and that one actually has quite a lot of application cross-sectoral, so all sectors of financial services that applies to, because where you're making use of cloud computing, so for example, Azure, things like Amazon Cloud Services and such like that, where you're using those rather than hardware internally, the FCA is taking the view that that actually constitutes outsourcing, because you can actually manage your own IT internally, you can store your own data internally. So they've actually put that in scope of sort of being outsourcing. Though again, for most firms, we'd probably class that as not being material outsourcing because of the size of the firm, the scale, and the number of clients and all of that sort of stuff. But again, it just points to that need to make sure that in terms of your internal organisation of how you manage data and your IT infrastructure, making sure you've given some thought to that and you've actually made sure that you've got appropriate data security primarily. The FCA has fined a few firms around this sort of stuff. Again, there's 3 instances up on screen. They are large industry actors, so it isn't sort of, an individual insurance broker. Couldn't see any instances of anybody as an individual, small, medium enterprise actually sort of being fined for this sort of stuff. But for example, there was a case against Raphael's Bank. So Raphael's Bank, they outsourced some of their IT infrastructure, and it meant that they had a period where they were unable to take card payments for a while, which caused detriment to clients because they weren't able to take payments and such like. So the FCA fines them for that 1.89 million. TSB, you might remember a few years ago, were making some substantive updates to their IT infrastructure. So they're using some outsourced IT infrastructure at the outset. They look to move that to a different provider. They hit a variety of issues with that transition. And it meant that for a period of up to 6 months, in the case of some clients, there was actually disruption to their banking accounts and banking activities, accessing their accounts, being able to make payments and such like. So there's quite a lot of detriment to their customers off the back of that. The FCA and PRA, because it's a dual regulated entity, both looked at that scenario, both very unhappy with it. They said there'd been no sort of proper management of the outsourcing arrangements. They'd viewed it as an IT only issue and not taking into account that there was a load of controls they needed to have around whatever they outsource. So FCA and PRA both really unhappy with that, and between the two of them, they levied a fine of 48 million quid on TSB for the issues. Again, it's worth being aware of, not particularly on the nose for us, because it's talking about a large-scale institution that causes a lot of disruption if it goes wrong. Doesn't have that many parallels with the way we operate particularly. Likewise, the fine of Equifax. So Equifax UK outsourced holding its data to, I think it was Equifax Canada. They put money and client data over to Equifax Canada. In Canada, there's different data protection regulations, and effectively there was actually a data protection breach, and a lot of Equifax's data found its way out into the public realm and available to hackers and whatnot. So again, the FCA looked at that and said, well, actually, you just haven't taken due care and diligence with your arrangements when you're outsourcing to them, to the Canada branch, because it's an internal outsourcing, but that still falls within the scope of outsourcing. And they were really unhappy with the way that had been managed. So effectively, they said there's been client harm off the back of this £11 million fine. So it is an area where the FCA has been fairly active, but I would say a little bit less so in the insurance space, because you'll notice there the examples are mainly about banking. So in terms of what the FCA expects, some of the key considerations and requirements when you enter into an outsourcing arrangement. So if you're going to place any sort of activity, functionality with an external firm to actually do on your behalf, they do expect you to take some care before you enter into that arrangement, and also make sure that your terms and conditions and contractual terms are consistent with their general guidance effectively. So one of the key points is that if you engage a third party to do anything on your behalf, so if you give them any tasks, functions, roles within your workflow, then the regulatory responsibility for all activities remains with you. So you can outsource functions, you can outsource tasks, you can get help in, but the responsibility for everything remains with you. You can't actually outsource that to the third party. They're not the regulated entity, you are, so the responsibility remains with you. So if they do something wrong and it results in the FCA actually taking umbrage with you or us for whatever reason, there wouldn't be much responsibility that you could actually shift onto the third party. You'd still be answerable to the FCA on it. There is also an expectation that where you enter into contract with a third party or you outsource something, the obligations towards the client under the regulatory system cannot be altered. So, for example, if you have an outsourcing arrangement or a third-party contract, it wouldn't be the expectation that there'd be any form of contractual agreement necessarily between the client and that third party for those services. The services are being provided by you as a regulated entity. You're answerable for it. You're the contracting party with the customer. And the reason for that is obviously if there's an activity being carried out by an unregulated entity, allowing them to contract with customers means that a lot of the FCA's sort of requirements and prerequisites might actually be bypassed to some extent, which is why the regulator is very firm that you can't actually change the relationship, so to speak. There is an expectation that a degree of due diligence would be done on third parties that you're looking to enter into a contract with. The amount of due diligence will depend on what the activity is and how complex it is and how reliant you will be upon them and how much harm they can actually do. The documents that we've sort of made available on Buddy today sort of include sort of some preliminary due diligence expectations and a checklist for things to look at. It's quite a comprehensive checklist, so it's intended to sort of cover off pretty much any scenario. So if it's something quite substantive, right the way down to something that's quite minor. The only thing I would say is if ever you come to use that, it is a case of you'd need to go through that and apply a bit of common sense about what applies, what doesn't, because we've set the bar quite high in terms of actually saying this would apply to any scenario. And for most of our firms, if you're going to use external resource, it's likely to be for virtual assistants and things like that. And a lot of the points in there would actually probably be possibly a bit over the top. So just to flag that, just to give you a little bit of context for the checklist if ever you do come to use it. Agreed service level agreements. So here, the FCA would expect that within your contracts for services or alongside that, there would be something that stipulates what level of service that third party is going to provide you with. And that's quite important because it sets expectations for the third party. It also enables you to make sure that you're setting a standard that means that the level of service you provide does not drop because you will have some degree of reliance on that third party potentially. That also gives you the ability to actually say, well, if we've set that service level agreement, we're monitoring against that. So there is an expectation that you'd have MI, whether that's provided by the third party or whether it's your own management information that actually gives you an indicator of whether or not that relationship and commercial arrangement is working and is successful, and whether it's delivering good outcomes to you and to your customers as well. And if it's not, there's an expectation that your contractual terms will allow you to do something about that. One of the general tenets of FCA guidance in this space is that undue operational risks should be avoided. So if you are going to outsource any activity, function and such like, it will actually add to the complexity of your organisation because there's more moving parts, there's more people. And if it's somebody that's actually sat outside of your firm as opposed to sat in your office, you might have less interaction, less control, less supervision than you would for somebody that's actually in your firm. So the FCA basically say that they would expect that where you are engaging a third party, it shouldn't be in a haphazard, negligent way. You should be thinking about how you're going to supervise them, how you're going to make sure that you monitor them, how that you make sure it is all working, there's no bad clienting outcomes that you're not getting wind of. So for example, if you were using a virtual assistant that's going to answer the phone for you, are you getting stats on sort of numbers of calls answered, time answered in, number of calls that hang up before they've been answered and such like, making sure you're getting wind if anything's going wrong. And so it can't be the case that the firm in the background can just sort of skate over deficiencies and the only way that you actually find out about it is through complaints. We have actually seen instances of that where firms have employed a virtual assistant to answer the phone for them, and we've actually then found that we've had several complaints come in for that firm because people have been unhappy because they've been unable to get hold of the brokers, their advisors, or they've actually tried to phone through and messages haven't filtered through. So we have actually seen instances of that, and that's probably something, which suggests if you are entering into any sort of external arrangement, you really do get a handle on how you supervise them and make sure it is working. Because if it's the case that the things start landing on our desk in the form of complaints, that's really an indication, firstly, that things aren't working with that third party. It also, from our point of view, begs the question about whether or not you're actually providing sufficient supervision if the first wind we're getting of it is actually from complaints. The FCA also says there should be no impairment of the firm's internal controls. Now, when we use the phrase controls there, what we're talking about is it's risk terminology. So when you identify a particular type of risk of any description, the FCA generally expects that you will have a control in place which will actually act to control the risk. So to mitigate it, reduce it, remove it, transfer it, insure it, or even accept it in some instances. But what their expectation here is that if you have controls to stop things going wrong for customers, then they expect that if you have an outsourcing arrangement, that there should be no real weakening of your controls effectively. So you shouldn't become more, so your control framework shouldn't get weaker effectively. So you shouldn't increase the risk to customers. And there should be a considered approach to how you actually sort of embed the outsourcing or the third party. The FCA also expects there should be no impairment of the regulator or Movo to oversee the appointed rep or their activities. And what that means in practice is that if you have a agreement with a third party, that agreement should include terms and conditions which basically permit the FCA to actually contact that third party, look at files, speak to staff, visit premises, all of that sort of stuff if needed. And the reason that's important is that if the third party is not an FCA regulated entity in its own right, the powers of the FCA are actually quite limited by the fact of the virtue that there's a third party in the chain that's not regulated. In that instance, if the FCA weren't able to complete investigatory activity because the contractual terms weren't satisfactory, that would be a finding against you and Movo effectively straight out of the gate. So if the FCA weren't able to investigate and look into things that they needed to look into, they'd actually say, well, hold on, there's a failing here, even before we actually know categorically what's happened in the third party. So that's probably a key point just to be aware of, that there's their expectation for the T&Cs to be such that the third party will be cooperative with any investigation that does need to go on of any sort, if you're unfortunate enough to end up in that position. The FCA expects that where there is an outsourcing, firms will retain the ability to manage the effectiveness of that outsourcing. So effectively, you should still maintain the ability in-house to actually carry out the activity and be able to adjudicate whether or not that outsourcing is working well for you and whether or not it's being carried out well. So it can't be the case you can outsource stuff and then just put your feet up and say, nothing to do with me, governor. There's an expectation that you'll actually know enough to be able to supervise them and have enough familiarity with what they're doing. They also expect that in the event that there is a substantive problem, that you should be able to actually bring things back in-house in a timely manner, promptly, in a way such that doesn't cause any great issues or problems for clients potentially as well. For large firms with large outsourcings, that point in particular becomes quite difficult because you then almost need to have a plan of how you bring things back on shore. If, for example, you'd sent a call center to India and wanted to bring it back on shore, again, probably not such an issue for all of us, because we're not going to be setting up call centers out in India and such like. But even sort of small scale outsourcings where we're using a third party firm to do things, also just need to keep in mind how you go about bringing things back in-house if you really needed to, and making sure that you do keep the functionality that you could do that if you needed to, even if it was translated, you need to beef up staffing at some point. At the point where you come to do it. That isn't to say you need to maintain staff all the way through necessarily, but you need to maintain the ability to actually oversee the activity. You need the ability to actually bring the activity back in-house, so the skills basically. You can amend these staffing levels as needed if that were the case. And then probably the final point, and again, it's quite a biggie, is making sure that there are adequate data protection arrangements in place. So bearing in mind that if you are going to transfer data or personally identifiable information to an external third party, you need to be mindful of what your terms of business agreement says to your customers. You also need to be mindful of what is said within your terms of business agreements to customers. Sorry, not terms of business, terms of business and your privacy policy. So what they say, and make sure that the transfers are conducted in line with what's been held out to the customers. Also need to be mindful of where that third party is based and if they will be transferring data overseas. Because if they are based overseas or the transferring data overseas, there's a whole host of additional requirements that come in under GDPR and data protection legislation, which you'd need to sort of make sure are built into contractual terms. And again, fundamentally, there's no additional weakening of data protection requirements. We've covered that one off in a bit more detail when we did GDPR a couple of months ago and in our policy. But fundamentally, if you were using an external third party, you'd probably need to do a data protection impact assessment to actually consider if there's any weaknesses created by the fact you're transferring data. And if that party is based overseas or it's going to be transferring data overseas, then if they're outside of the EU, you'd probably need to do a transfer risk assessment as well. So it gets a little bit more involved. And to be honest, for most firms, if you're literally looking at a virtual assistant or administrator, the work involved in all of that stuff probably is probably offsets the savings you make by actually bringing somebody in. So that's background on what the FCA expectations are at high level. In terms of the policies that we've launched and made available as of today on the extranet, so just to summarise some of the key points from those, there's two documents. So one is the outsourcing and third-party management policy. That is a Movo level document, so it's about Movo itself, what we do as an entity. There's quite a lot of technical knowledge in there. Sorry, could I ask people to go on mute if you're not. So there's quite a lot of technical knowledge in there, which is relevant to anybody that's outsourcing. But there is some more specific guidance, which is aimed at appointed reps that are looking to sort of do things like, bring in a virtual assistant or whatever, which is the outsourcing guidance for AR's document, which is a bit shorter, a bit more pragmatic. Both documents include the outsourcing checklist that I mentioned earlier, which is what you use to complete your due diligence. I would just say, reiterate the point, that's quite a comprehensive checklist, and it'd be one of those where you go through that and just make sure you've considered, thought about things, and then populate the fields that are actually relevant. And then once you've actually done that, you'd need to send that over to the compliance team, so compliance at Movo Partnership, and let us have a look at the arrangement that's proposed before you actually sign contracts. In terms of our interest in this, we don't want to get too intrusive about sort of, how you employ third parties and outsourcing. So in terms of your third party contracts where it's not outsourcing, we don't ask you to do any of this for that. It's literally crack on. If you want to get your own software and such like, crack on. If you are looking at outsourcing arrangements, because where there's an outsourcing, that potentially creates risk to you and to us if things going wrong potentially, and it comes within the world of the FCA. In that instance, we do ask to actually sign off on outsourcings that come into play. And generally, the things that we'd look for when you send through your checklist to us is we'd look to check that there's that the outsourcing itself isn't material. So, for example, we wouldn't expect there to be one CF1 within our AR, and you're actually sort of setting up a call center with 50 staff based in India looking to do telephone calls to actually sell, because it quite clearly would be material. And we would then have the obligation to make sure we're supervising all the activities in that call center, which we don't want to do. We aren't going to do. It's not, it becomes excessive. It isn't what we geared up for and what we'd expect from our ARs. So no material outsourcing is sort of the starting point. The other rule of thumb is that we'd suggest that no regulated activities should be outsourced. So that one gets a little bit tricky, because actually identifying whether or not a particular task, function or activity is regulated isn't the most straightforward thing. I'll be quite honest about that. So within the policy and the guidance that we've drafted, we've basically mapped the guidance from the FCA that's available and said these activities are regulated, these aren't, and tried to give some guidance on that. We'd basically ask if you are going to employ anybody externally, that you try to sort of adhere to strictly to what's actually documented in there, because that's actually your safety net and our safety net. By and large, the rule of thumb is that a unregulated firm cannot carry out activities that are considered regulated. In my view, there's shades of grey about how that works if it's an outsourcing and we retain responsibility for it. But having reached out to several external consultancies, the feedback that we've consistently had is, in the first instance, has said that an unregulated firm should not be asked to carry out regulated activities. So hence the guidance in our policy basically says that the activities that can be outsourced can't be regulated activities in their own right. It can be component parts, it can be tasks, it can be things that help you with admin as opposed to actually being regulated activity. If you are outsourcing to a third party who themselves are regulated, and that will often be the case, for example, in terms of claims management and stuff like that, In that instance, it is possible to actually outsource a wider array of things, but that's something we'd look at on a case-by-case basis. But that would sort of come down to what permissions they hold with the FCA and what activities you're actually looking to outsource. So that one is a bit more of a moot point, a bit more flexibility potentially. As a rule of thumb, regardless of who you're looking to outsource to, we wouldn't agree to any sort of sales activity being outsourced. So all of your sales activity with clients, all advising and arranging, so non-advised sales activity, needs to be completed in-house by your own in-house staff that fall directly within Movo's direct supervision. Obviously, if you're sort of looking to outsource any of the sales activity, again, that point about regulated activities becomes relevant. And even if they're a regulated entity in their own right, we still then need to absorb supervision of them, looking at competency, all of that sort of stuff. So again, it's something we don't want to particularly sort of move towards. And then finally, data protection. We've already touched on that a little while ago. In terms of things that can be outsourced, so we have a list up on screen there. You don't need to take a screenshot of that. That list is recreated in the guidance that we've got available within Buddy, and I'm not going to talk through this extensively. The one thing I would say is that within insurance intermediation, most of the things that we do in-house, or a large portion of them, are actually regulated activities and explicitly called out by the FCA as being a regulated activity. So largely speaking, in terms of things that aren't regulated activities, you are largely looking at purely administrative tasks where somebody's operating with a low level of autonomy. And generally speaking, the area where you need to be a little bit wary with is if somebody's interacting with customers or they are interacting with insurers, then you need to have very tightly constrained guidelines as to what they can actually do, because the interactions with insurers or customers become far more likely to become a regulated activity. So, for example, things like chasing premiums where they're due and sending an email to a customer to say that the payment on XYZ policy is due this month, can you transfer funds? That's not regulated activity that can do that type of thing for you. Asking them to pull together internal documents for you with the broker, the internal broker having led the interaction, they can do that for you. Sending stuff off to insurers becomes a bit of a moot point because the first interaction with insurers in various instances is actually regulated, but some of the more mundane sort of interactions with insurers are less likely to fall within the scope of regulation. So I'm not going to go through everything that's up on the slide there, so that's just to have a read through, and obviously it is in our policy documents as well to have a read through. But if you do look at outsourcing anything, you should be taking a good look at what's in that guidance and trying to make sure that you map your activities so it's actually in line with what's suggested there. As can be outsourced. In terms of things that can't be outsourced, this is actually a bit more clear cut because the guidance is actually a bit more straightforward on that one. By and large, you can't outsource anything that sort of involves selling effectively. So if you're sort of wanting to sort of have somebody that's actually generating leads for you, then as an introducer, they can't be sort of doing a phone around to sort of contact people. And if you are looking to sort of employ a third party who's actually going to be doing more than introducing, then that needs to be done in-house, because again, somebody externally doing that would fall within the requirement to actually be fully supervised and in scope of our T&C scheme. And it's actually a bit of a moot point if they're not a regulated entity, if they could actually even physically do that without breaching FCA rules. So any client-facing sales activities shouldn't be outsourced. Negotiating terms with an insurer or a client, again, you might make the argument that if you're pinging emails backwards and forwards that's admin. From an FCA point of view, it's not. So if you're talking about things like warranties and such like that, and conditions and things like that, that's actually negotiating. So the emails to the insurer or the emails to the client actually constitute a regulated activity very clearly under FCA rules. One of the ones that is possibly a little bit of a surprise is that completing a proposal form and then submitting it to the insurer. The FCA again explicitly calls that out as a regulated activity. There are some nuances about that. So for example, if you had a broker actually having the call with the client and sort of making notes and pass the notes on to external resource who was actually going to populate the form for them doing the admin, then provided that was the case and the actual form itself was submitted by the internal broker rather than the admin, there is scope that the admin can actually help with the legwork. But the actual sort of formal stuff has to sit with the internal staff member because it's regulated activity. There is a bit of an oddity in the FCA handbook in that they say that collecting premiums generally isn't a regulated activity, but collecting premiums from a client pre-contract would be a regulated activity. So, for example, if you were asking for deposits, things like that before the contract's actually been incepted, I don't think you're likely to do that, to be honest, but if you did, that's actually regulated activity. So worth being aware that on the premium collecting point, there's some nuances there. In terms of claims handling, this is one of the ones that crops up. Claims handling under the FCA handbooks is generally considered to be assisting in the administration and performance of a contract of insurance. So if you are, for example, completing the claims form and sending off the first notification to the insurer, that's actually regulated activity. So your third party couldn't do that. Giving somebody guidance on how to submit a claim. So actually, if they're phoning up and saying, I'm filling in the form, I've got a question, can you answer the question? That isn't regulated activity. But it is that, it is quite a nuanced area, which you just need to be aware of that with the claims handling stuff. By and large, it's preferable that's done in-house, or if you have any relationships on that front already, because we do use external claims handling for various bits and pieces, that's generally going to be sort of regulated activity and need to be done by a regulated firm in the background. So by and large, the rule of thumb with regulated, with outsourcing, is that you should be looking to try and make sure that anything that you send out externally is administrative in nature, limited autonomy, and they've got very tight guidelines as to sort of what interactions they'll be having with customers and with insurers to try and make sure that you're not falling foul of the quite complicated framework as to what constitutes a regulated activity or not. It's not particularly conducive or helpful to outsourcing, the fact that there's so much of what we do actually falls within regulation through some nuance or another. So that's a whistle-stop tour through FCA expectations. So I've talked about what the difference is between outsourcing and a third-party contract. And as I mentioned earlier, Movo has much less interest in sort of where you enter into third-party contracts for services, but where you are outsourcing to somebody to actually carry out any of your functions, activities, provide you with external resource, we are interested in that because there's risk to you and to us in the background. Albeit we don't want to be overly intrusive in that area. We've also talked about some of the key considerations that you need to think about if you are going to outsource or obtain services from a third party. And we've also talked about some of the key requirements from Movo's policies which have been published in respect of outsourcing and third party contracts. So that brings to an end the formal part of my presentation. So I think I'm just over 40 minutes, so I'm about right on time. So at this point, Pete, do we have any questions?
We do, Nick. We've got quite a few, actually. I'm going to start with the first one from Lucy, which asks, would using a marketing agency be a contract for service?
So yes, that would generally be a contract for service, provided that they're sort of drafting things and so yes, by and large, I'd suggest that that's actually a contract for service rather than full-blown outsourcing, particularly if they're sort of drafting things and you're having the final approval on it. If you were giving them full autonomy to do stuff, then yes, that becomes outsourcing. You need to step away from that because, again, actually carry out marketing activity can be a regulated activity in its own right in some circumstances. So it needs to be the case that everything sort of is done with your approval, your sign off, and Movo's as well. Generally speaking, employing an outsourcing, a marketing agency, I would suggest is likely to be a contract for third party services as opposed to full-blown outsourcing.
Thank you. I have one for Neil. So they have lots of services that do not appear on the list. As Lucy has mentioned with marketing, but they also do have accountancy, bookkeeping, payroll, VA, EA services. Are all these deemed outsourcing?
So accountancy is contract for services. Bookkeeping, again, I'd probably suggest that's actually contract for services because you're not expected to necessarily be your own accountants, bookkeepers. You could employ somebody to do it in-house, but it's not, you know, a core part of your day-to-day activities, being an insurance intermediary. VA, a VA would be outsourcing. So that one, we have some interest because again, that could actually lead to poor client outcomes potentially. EA, so employee assistance. So employee assistance, again, that isn't something we'd expect your typical intermediary to do because you're sort of saying you've got access to HR support, helplines and such like, not part of your core day-to-day activities. So in that type of, executive assistant. So yes, executive assistant, that's effectively outsourced labour. So you're actually asking somebody externally to do labour that you could be doing internally. So yes, that would be outsourcing in the same way that a virtual assistant would be.
Thank you. We've got a few more from Lucy. So they use insurance support solutions.
Yep.
They do some broker administration and they have a contract in place and a documented process for each activity they do. Are we covered off on that basis?
So a little bit difficult to answer that because there's various bits and pieces that need to be in contracts and it depends on what's there. We are aware of Insurance Service Solutions, so they're a reputable provider as far as we're concerned. So my guess there would be that you probably have got everything in there that needs to be in there, would be my take, because they're actually a well-known industry body. But again, I can't categorically say that because I haven't actually reviewed per se, but it's a case of just sort of making sure that you have a look at sort of what we've spoken about, and try to sort of make sure that you're actually happy that you've actually got everything in place by and large.
I'm following on. Oh, sorry, Nick.
I was just going to say one of the things that I would just mention is that one of the things that we are considering internally, it's not yet sort of live, it's not something we can actually make an announcement on. It's one of the things that we have thought that we are thinking about is whether or not we offer additional resource internally within Movo to offer outsourced support, basically sort of resource augmentation for tasks, with a view to sort of that being a payable service for people, because obviously we're a regulated entity, we're the principal. So in terms of supervision and sort of defining where the boundaries are, it'd probably work quite well for our ARs if we offered something to support with resource. But at the moment, that's sort of very much sort of, you know, on the drawing board as something that we are thinking about and considering in the future.
Smashing. Another one from Lucy following on is, how about a post-inception email to clients with info about other products that they have, including cyber? The text is given by Lucy and not deviated from by an outsourced firm.
So in that instance, the marketing, if the email is going out from a third-party firm, I'd probably still make the argument there. This one gets really quite grey, so I'm debating this one because again, if a third party, we've had instances where we had breaches on marketing, where a marketing email has been drafted, sent over to a third party to actually send out as a mass email and given a mailing list. And we've seen instances where that has actually gone out incorrectly, so it can lead to client harm. By and large, I'd probably go that provided the actual mailing has been drafted by you and is designed by you, approved by you, and they're just literally sort of sending it out on a mass mailing as being from you, I'd probably make the argument in that circumstance that that's actually a contract for services. But that one, as I say, gets quite grey.
Okay, and we have a question from Mike asking, can you clarify the code calling to customers point again, please, and why this needs to be considered a regulated task?
So yes, the reason being that in terms of creating introductions, so for an unregulated firm, there's quite limited activities an unregulated firm can partake in to generate leads for insurance. Some of the definitions of insurance activities include, for example, arranging, and the arranging is actually quite a broad definition, so it includes discussions of particular features and benefits and such like. It isn't literally sort of at the point where a customer signs on the dotted line. There's actually stuff that precedes that, so having discussions about what policies cover, what their needs are. An external agency could have a generic conversation, very generic conversation, but they can't get into specifics on it. So if you've got a entity that's looking to actually contact customers to drum up business, The moment they start getting into sort of detailed conversations with them, it's likely to become regulated activity. So in terms of external parties actually sort of doing cold calling for you, that sort of stuff needs to be extremely tightly drafted and monitored. So we'd say as a general rule of thumb, if there's sort of sales activity, outbound calling and such like, that needs to be done in-house, because then you're actually safe because it's been done by a regulated entity. So I view that type of activity with quite a lot of suspicion is the wrong word, but a great deal of care needs to be sort of taken with those sort of activities. On that one, there is guidance that we've got published on introducers and IARs. That's relevant. That's probably a starting point for that type of activity, because it outlines what somebody could do externally and just be classed as an introducer. But if they go beyond sort of introduction activity, then they need to be a regulated entity, which then becomes problematic.
Smashing, thank you. That's all the questions so far, but if anybody does have any others that they want to pop in the chat, or if you want to take yourself off mute and ask, please please do so. So I've got one from Neil. Oh, hang on one moment, Lucy, we'll come back to you in a second. So Neil has asked, how do all large brokers deal with lead gen? They all use outsourced cold calling.
Yeah, I can't actually comment on that. That's one where my guess would be that they've actually got a very carefully crafted agreement with the third parties as to what can be said, what can't be said, which is likely to actually stay within the rules. But that needs to be done with a great deal of care, would be my guess. It might even be the case that the third party themselves are actually a regulated entity. And so of the view, having had legal advice, that they're actually able to do it. That would be my guess, but obviously I can't actually speak on behalf of those entities.
Okay. Lucy, have you got a question?
Would it be okay to send over a list of the tasks that we're sending to Insurance Support Solutions and just confirm that you're happy they're all not regulated?
Yeah, please feel free. If you ping that over to the compliance inbox, we'd happily have a look at that. Thank you.
Thank you.
And we do have another question from Clive. What about managing agents who provide information on the properties that they manage?
Okay, we're on into a different topic area with that. So managing agents, so in terms of multi-occupancy buildings insurance type stuff, property managing agents may well be carrying out insurance activities. So there is actually guidance from the FCA on what and where a managing agent would be carrying out regulated activities. So in that instance, they may need to actually have authorization themselves, either as an AR or through through direct authorization. In some instances, they have exemptions because if they're, for example, they're a member of RICS and such like, they might be exempt from FCA regulation by virtue of that. Otherwise, those agents need to sort of be mindful of the fact that if they're talking about insurances, they may well be getting into the territory of actually being carrying out regulated activities, and so that could potentially become problematic from their point of view.
Amazing. Any other questions?
And I would just note actually on the multi-occupancy stuff, we are looking at sort of publishing some guidance on that in the near future, and possibly doing a webinar on it, because that is a little bit of a minefield in terms of the FCA guidance that sits around that. So we are thinking that's one that would probably be quite helpful for us to do an event on at some point in the future. But even then, that's still quite difficult because there's still lots of shades of grey in interpretation on that one, I'm afraid.
We've got one more question from Richard. They use Zywave for content, which we send to clients. He believes this is all okay as it is approved.
So if you're using an external party who produce marketing content for you, provided that comes into you, you approve it, you treat it as your content effectively, and you're just paying them to actually draft content, send it over. So you're saving on resources sorts, but it actually remains in your wheelhouse to actually approve, send out, all that sort of stuff. I'd view that as a contract for third-party services.
Any other questions before we wrap up?
Okay, that being the case, I'm going to stop recording. And I'll stay online for a few minutes after. So if anybody wants to have a chat or raise questions that they weren't happy to raise when everybody's on the line or it's been recorded, please feel free. Thanks all. Cheers.
Thanks, Nick.